Hello, friend. Welcome back to the weekly live series from Lawyers Design School. It's legal design thinking in real life. My name is Hannele, and I'm the founder and CEO of Lawyers Design School, and I'm on a mission to transform the legal space with human-centered design, better known as legal design. And I'm teaching you how to add creative and human touch to your everyday work so that you can be the lawyer that your clients and the world needs you to be. Today, I'm going to talk about the legal side of contract design. We'll address the question of whether simplification of contracts is actually legal. And I'm putting my lawyer hat on, this is funny. This feels a little bit intimidating, actually, to be putting my lawyer hat on these live sessions. So let's see how it goes. The background for this talk is that contracts are basically legal instruments that have legal implications, that are regulated and that have a long history and tradition behind them. All of that has naturally impacted the way contracts are today, the way they look and feel, and the way lawyers write them. Simplifying contracts with contract design certainly challenges these old traditions. And many times people's first reaction to the very thought of contract simplification is that legal? Can we really do that? And my intention in this episode is to give some viewpoints around this theme that is hopefully helpful for you. But at the same time, this is my invitation for you, all my fellow lawyers, to join the discussion about legal obstacles you see for the simplification of contracts. So come on in and make your argument for and against. I'm super interested to hear them. So let's dive into the day's topic. A quick story from my past as a corporate lawyer to give you some context to all of this. Back in the day when I was still in corporate, I worked as an in-house counsel for a bank. And in 2007, as some of you may still remember, the European Union started out this humongous regulation tsunami for financial markets that is still going on this day. And the first wave of this tsunami was called MiFID, abbreviated from Markets in Financial Instruments Directive. I know, sounds so horrible. But that regulation basically set the ground for simplification and redesign of contracts related to financial services and the related risks for non-professional investors. Well, nobody used those terms like redesign and simplification at that time. But anyway, all of a sudden, I was in a position where I was required to translate the super complicated regulatory information in the language that any mom and pop would understand. And at the same time, I was in a position that I had to make sure that those contracts give every piece of information that may have relevance to the investment decisions that those moms and pops are making. I mean, dozens and dozens of pages of contracts in an understandable way. And it felt like a mission impossible at that time. And in many ways, it actually was. So we did what we could at that time, but I wish that I had the same understanding, especially the contract design framework and the tools that I now have, because simplifying contracts was exactly what I was asked, what was asked from me by law, and I didn't know how to do it. Well, luckily, the framework and the tools are now at your fingertips. So if you're working with complex contracts, and especially in the heavily regulated industries, or you're working with contracts that should make more sense to your users, I hear you, and this episode is for you. First, let me briefly explain what I mean by simplifying contracts to those of you, if there are any first-timers listening to this. By simplifying contracts, I mean that you take a complicated legal contract that looks like a serious legal document, small font, fully justified, non-existing spacing, no white space whatsoever, that is full of legalese. The more text, the better. That includes paragraph-long sentences that are impossible to read, and that hides the beef that your customer is looking for, the price, that action item. Nobody can find it. The way the contracts nowadays are. And with simplification, you basically make it more simple, with a clear and user-friendly structure, with plain language and visual aids to help the user. So that's the definition part. But this is where our tradition from legal space come from. Traditionally, contracts are written for and by lawyers, and the purpose of the contracts is to prevent disputes. But surely the parties who are signing the contracts and who are affected by the contract need to understand the content. I mean, if your colleagues or customers do not understand their own contracts, how are they supposed to know what their rights and obligations are and what they should be doing to comply with that contract? And regulators are increasingly paying attention to the dilemma of complexity and the way it makes it so difficult for people and businesses to exercise their rights. And in response to this, many regulations already demand companies to simplify their contracts and legal information in order to make it easier and accessible for people. MiFID was one example from that already 15 years ago. Another example is EU's data protection regulation from 2018, GDPR, that requires that companies must present the privacy information in a way that makes it possible for the user to understand how their information is being collected and processed. If you have not been living under a rock, you probably have noticed how companies have found privacy policies to be a good starting point for their contract design journey. So many great and inspiring examples of innovative, visual, and informative privacy policies out there. Easy to understand means easy to follow and easy to comply with. And simplification increases transparency, and transparency increases trust for you, for your customer, and for anyone else who is involved in the deal. And this serves both you, your customer, and their customers and partners, and also the regulator. When I talk about the simplification and whether it's legal or not, I can almost hear your counter arguments. You might be thinking, but it's the law. What if I can't change anything? There certainly are situations where you need to include certain written information in the contract or even use specific legal language so that the contract is valid. For example, the content of an employment contract is often regulated and codified. You need to include certain information in writing in an employment contract and use specific legal terms so that the contract complies with the employment contract regulations. Well, this is your expertise as a lawyer. This is your wheelhouse to know what these requirements are and make sure that the contract includes what is needed. But even in these situations, I urge you to revisit the regulations and see what they really require. Do they require you to use expressions like shall or notwithstanding the foregoing? I doubt they do. So many times lawyers overestimate the impact regulations impose on specific contract language and also underestimate the room for simplicity. Many times it's the tradition speaking, and you can change that. So be mindful of the difference between what is actually required and what is just copied for the sake of tradition. Another point I wanted to make is around contract risks. In my experience, lawyers do not like taking risks. I don't know about you, but I surely didn't. We want to be sure that we covered every single scenario in our clauses and contracts. And by doing this, we overlook that this approach results in overwhelming contracts that are all about us lawyers and forget everything our customers need to know. And I get it. Complex contract language is the language lawyers can speak. And it's easy to just continue speaking in that language, especially when change means that you would need to reevaluate the risks that are involved with the simplified language. But here's the discussion that I recommend. A perfect opportunity for a team meeting and involving a diverse team into discussion. What is the level of uncertainty you and your business or team are willing to accept? When you write contract texts, how much inaccuracy in your lawyer mind are you able to tolerate? Or is a certain way of writing more about you and your need to express yourself in a certain way, to be accurate and always correct to the last detail? And then after this analysis, challenge this level of uncertainty and inaccuracy to extend further. Ask yourself or brainstorm with your team, can you find alternative ways to say something and still cover the most important things and risks? And would you actually be helping your customers more with a different kind of language, more simple one, even if it didn't cover each and every scenario you can think of? Simplifying contracts is not about dumbing down or opening the doors for uncontrollable risks. Simplifying invites you to learn a new language so that you can serve your customers better. You can speak your customers' language. After all, the contracts are not about and for you. Okay, that was about language, but what about pictures and other visual elements in contracts? Are contracts supposed to be just writing, or can they have images as well? Is that legal? The answer is yes. Valid contracts can include images, illustrations, and visual elements. It's impossible to give any exhaustive example that would cover every jurisdiction to support this, but you can refer to one case law example from UK and go out to find your own case law to support your jurisdiction. This case that I'm referring to, I will put the link in the show notes. That case of Altera versus Premier Oil actually resulted in a recommendation to use illustrations to explain complex content. And at the same time, this case law example is a good reminder that the same rules and recommendations that govern contract text apply to illustrations as well. Don't be confusing. That's a good thumb rule. Ultimately, the use of visuals in contracts is not a black and white question. The idea is not to replace the text with visuals, not even in comic contracts. Simplification means that you can use illustrations and visual aids to support the reading and understanding. You can add a diagram or to explain a process or certain timelines and still have the clause written next to the diagram. You can have them both. This will help all users, not just those who have challenges with reading. So I challenge you, when you think about your contracts, can you think of a clause or content that could use some visual aid to help the customer to understand the meaning? One really useful and practical way to approach the whole dilemma of simplifying contracts and ensuring their validity is a tool called layering. I learned about this technique from Rob Waller from Simplification Center, and I've actually talked about this layering more in detail in episode 15. But shortly, the idea behind layering is simply this. You don't necessarily have to change the original content at all, if that's too scary, or if you even can't touch it. Sometimes you just can't. You can simply create different layers to the contract for different users. Since there are many users for the same contract, you can serve each of them with their own layer. And these layers can actually live in the same contract document. You can think about the original contract language as the source code, and the other layers are then user interfaces to that code. Like any app in your mobile phone, they have the source code that only software developers can read, and then there is the user interface of the app that you intuitively know how to use. The same logic is totally applicable to contracts as well. So there you have it, ways to approach the question of whether simplifying contracts is legal. If you're interested in contract design and are curious to see what it could look like in your work, I have a great free resource for you. It's a starter kit for contract design, and it helps you to hone in on the ways you can get creative with your contracts. Go to lawyersdesignschool.com/start and get your free resource. It's lawyersdesignschool.com/start. Now it's your turn. What did you learn today? Be sure to follow the next episodes where I will be sharing more insight on legal design thinking in real life. Thank you for joining me today. Have a great day. Bye.